Most people want to know, how are their creditors notified when they file bankruptcy. We don't actually write the creditors a letter. If once somebody has retained me, paid a down payment, they can start telling creditors to call me if they're bugging them. There's no need to contact a creditor who's not bothering you to let them know anything, because basically, they're not bothering you. But when you file the bankruptcy, that's actually, the paperwork is emailed to the court. That's the minute you're in bankruptcy. The court sends a notice out within probably a day or two. It actually tells the creditors, that you have filed bankruptcy, when you filed bankruptcy, who your lawyer is, the lawyer's name, address, and phone number, who the trustee who's handling the file for the court system is, where their hearing is. There is a hearing set that you have to go to 30 days after you file, and the trustee runs the hearing, and basically all creditors are notified of it. We call it the 341 hearing, but it's called the meeting of creditors. Creditors can come if they want, but they usually don't. And so that notice is very important to give everybody due process, so creditors can't come back later and say, I didn't know about your bankruptcy and I wanted to ask you these questions. So it really protects you. But they get that notice within a week of filing. You'll get a copy of it. We'll get a copy of it, and we'll send you a letter with a copy of it with it. So you'll get 2 copies of the notice. And the creditors are also told that if it's a Chapter 7 case where your goal is to discharge the debt, they're told not to file a claim with the court, which means they don't really have to do anything. It also gives them a 3-month deadline to object to your getting rid of their debt if they want to, and that means they have to go hire a lawyer and take certain steps to get rid of to make it so you can't get rid of their debt. And basically, that's all the notice that goes out. And then if the trustee in a Chapter 7 decides there are assets he can sell, which is very, very rare, he will then send a notice that tells them to file a claim to get paid. And that doesn't happen much because there usually aren't any assets that are sold in the Chapter 7. If somebody files a Chapter 13, the same notice goes out, same information's in it, but it tells the creditors they must file a claim within 4 to 6 months, depending on the type of creditor they are, or they won't get paid. And if they don't file a claim, they don't get paid anything. And so basically that's the kind of notice that creditors get. What we do is if a creditor continues to bother you, write you, call you, anything, you need to tell us. And we tell you to keep in touch, because 4 years later you may have some creditor who bought a bad debt that was discharged in your bankruptcy. They may contact you. You need to let us know. We have letters we send to them which basically tell them they better leave you alone, or we can sue you, in which you can. We can sue the creditors for contacting you after your case is over or while your case is going on. Typically, we send that letter out one time, sometimes twice, for them to get the message. Ultimately, they quit leaving you alone. They quit bothering you. And basically, that's the notice that creditors get for a normal case.